Um, Good day, everyone. Am I audible? Can everyone hear me? Good day.
Good day, sir.
All right, thank you very much for confirming that I'm audible. You all are welcome to today's session rather. This is the fifth week of the fourth quarter of mentorship. We've gone through week 1, week 2, week 3, week 4, and then we are currently in week 5. And slowly we are getting towards the end of the mentorship program. Thank you so much to all our mentees for being diligent enough to keep up with the process starting from the first week up till now. We thanks again to our mentors for also following us through with this journey and also coming always being available to help our mentees learn more as they go through this session and this class. So today our class for today is tagged IP protection of AI and ChatGPT, IP protection of AI and ChatGPT. And I will just be taking the announcement quickly. We will not be displaying them since we've been displaying them over and over again. So I will just be saying them verbatim. So registration for first quarter 2024 is still ongoing. We started taking mentees for ahead of first quarter for 2024. So please, if you are interested in joining this program, if you have friends, colleagues, family members who are interested in joining this program, you can let them know that mentorship program is ongoing in JIIPCC at JIIPCC, JIIPCC, right? And if you want to also pick another course, you know the list of courses we have. We have artificial intelligence, we have intellectual property, entertainment, business and law, data privacy and protection, entertainment, business and law, entertainment, business and law, blockchain, metaverse and NFT, and patent drafting. So if you are still interested in any of these other courses, you can still come back next quarter and pick any of them. So thank you so much for that. The opportunity to still be a part of the 30 minutes one-on-one mentorship is still open. You can still register. We are not done with the registration for that. So if you are still interested in 30 minutes one-on-one mentorship, please, you can send a direct message to me and I'll make sure to guide you appropriately. So we'll just be going straight to introducing our mentors for today. We have three mentors on call. We are supposed to have three mentors on call rather. And our first mentor for today is Professor Samuel Samai Andrews. Professor Samuel Samai Andrews is a member of the faculty at the College of Law, Prince Mohammed bin Fahd University, Al Khobar, the Kingdom of Saudi Arabia. He is also a U.S. ambassador, distinguished scholar and professor of intellectual property law. He holds an SJD degree for Suffolk University Law School, Boston, USA, and LLM and in intellectual property law and policy from the University of Washington, Seattle, USA, and LLM in international law and jurisprudence, and an LLB honors from the University of Uyo, Nigeria. A former managing partner of ZFC Law, Zell First Fruits Chambers, Port Harcourt, Nigeria. He was also formerly professor of intellectual property at the University of Gondar School of Law, Ethiopia. Welcome, Professor Samuel Samai Andrews. Welcome to today's class. I can see he's already on call. But before we have him come give an introduction into today's topic, we'll also be introducing our other mentors. Our second mentor for today is Mr. Matthew Harvey. Mr. Matthew Harvey is the head of AI and partners at Golin WLG UK LLP, advising on AI across all sectors. He is co-editor of the Law of Artificial Intelligence Suite and Maxwell. He is a trusted intellectual property advisor, especially for clients with complex with complex disputes, including SEP France litigation. Legal 500 has described him as standout and absolute superb for patent disputes. His cases have involved video compressions, telecommunications, 2D, 3D, LITs, and DSL rather, and other standards. Aircraft design, software, algorithms, trainings, consumer share trading platforms, 3D modeling, consumer electronic, inkjet printers, location sensing, and traffic analysis. He has extensive experience in healthcare and life science work, including monoclonal antibodies, um, biosimilars, toxin, medical devices, and cosmetics. Um, he has handled products clearance and disputes involving copyrights, trademark designs, and confidential designs for clients in the aerospace, retail, fashion, automotive, and financial service sector. He successfully defended the Kennedy Trust for rheumatology research in the UK first biosimilar disputes and helped win Fujifilm Kyowa carrying Biologics Co. Limited, the first UK arrows declaration. That's our second mentor for today, Mr. Matthew Heavy. Our third mentor for today is none other than Our third mentor for today is none other than Mr. Gabriel Udo. Mr. Gabriel is a research fellow at the Robotics and Artificial Intelligence Law Society, RAILS, Berlin, with a strong passion for intersection of AI law, ethics, and society. He is a PhD candidate at the European University Valdrina, focusing on the law and ethics of autonomous weapons systems. His expertise span topics like robotics, smart city technology, digital colonization rather, and privacy. He is also proficient in Python programming and data analysis. Welcome, Mr. Udo. Thank you so much, sir, for joining us. Thank you so much, sir, for joining us. Okay, we would like to welcome our first mentor for today, Mr. Samuel Samai. I can see on the chat box he sent a message. And we'll be having Mr. Samuel, Professor Samuel rather, to come give us an introduction into today's topic. Welcome, sir.
First of all, I gotta correct you. I'm not happy right now. I sent an information to you. You have to correct that thing immediately. In the era of digital, it could be damaging if you put my information wrongly. I drew your attention to this the last time. So don't make that mistake again, okay?
I'm so sorry.
No, it's all right. Let's go ahead.
All right. Thank you very much.
All right. I'm going to share a short presentation here. Let's see. Please let me know if it's been shown. Is it shared? Okay.
Yes, sir.
All right. Okay. Because it's mostly, this program, I think, is mostly for our mentees to speak to us, and we take it from there and guide them along. So I am going to talk on the theme IP protection for AI. I kind of took the liberty to change my presentation to be IP protection and LLMs, because your topic talks about IP protection for AI and chat GPT. My understanding is that chat GPT is just a specimen or a species of large language models. So it's like Bonvita or Coca-Cola, Pepsi, what we call soft drink, in our parlance in Nigeria. So Chat GPT is just one of the companies, one of the products, that does what we are trying to look at. Because we have so many of those models, you will see now, Gabriel knows about them very well. We have so many of them now. The initial ones were things like Dale, Bard, and we have a lot of them now. So, lucky enough, we had a judgment 2 days or 3 days ago in the United States. That has been the first case on this infringing issue of LLMs and generative AIs. So there's a case that came down on the 30th of October. Sarah Anderson in the United States District Court of Northern District of California, Anderson, some creators, led by Anderson, sued a generative AI company, Stability AI Limited, and some other companies. They sued them for copyright infringement and some other issues. So why I'm bringing this case up, because it's a new technology, it's a new space we are dealing with, and we are still struggling. Both the operators of the market, both the technologists, we've not really figured out yet the impact of how generative AI systems or how the courts will determine the infringing activities. So this case has come down. It's not presidential yet, because it's, this kind of cases might lead us up to appeals, even the Supreme Court, before we really know. But we are beginning to see how the courts will deal with these issues of generative AI infringing on or copyright infringement or trademark infringement, or generally intellectual property interface with generative AI. So we all know that AI is all about technology. We know that it's a function of the digital era that we have. And the issues that I would draw the attention of our mentees to when it has to do with generative AI, example, ChatGPT, should be how would this interrelate with a creative right? How will you say that because someone has created a product, for instance, ChatGPT, which is a generative AI, how would that infringe on, for example, someone's copyright? How would that infringe, for example, somebody's patent or trademark? And in that stream. So now, this case has shown, because the court already has dismissed virtually most of the claims of the plaintiff. The only claim I think that is left now is maybe the most important claim. To really see, the court, they might have to file again or amend their claim to see if the generative AI system of Stability AI, which is known as Stable Diffusion, whether while they were training on the data, whether they infringe on any of the copyrights of these plaintiffs. What do I mean by that? We know that what this generative AI system does is that they go onto pre-existing data on the web, what we call technically scraping. They scrape the website, use pre-existing data to train their own system to replicate or to do whatever they want them to do. So that means, I'm using copyright terms now, or I'm staying with the copyright area because it's mostly right now the copyright issues that we are seeing, the creative rights. So that means, in essence, we might have a problem. Is this, let's use ChatGPT. Is ChatGPT, the data that has been it's training on, is it fair use? Is it fair dealing? Is it derivative? Um, uh, 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 is it working on a derivative space? So now we also have the problem of, do we know the technology? As lawyers, do we even understand the technology? Because I think you should be able to understand the basic technology before, because copyright law is not going to really change in the basic principles of copyright. Is that if you copy someone's work that copyright protects, you infringe. I mean, that's the basic elementary primary definition. So will all these new technologies, the application of these technologies, does it implicate copyright law or jurisprudence? Does it really change how we look at infringement? And from what we are seeing from the court based on this case now, is that the court copyright will not change how the court looks at copyright, the rules of copying, substantial copying, access to the original work, and all those rules that the courts use to arrive at whether you have infringed on somebody's work will not change. So if you are alleging that, for instance, ChatGPT has infringed on perhaps your copyright, then you still have to tell the court what are those works that ChatGPT has infringed. And that also brings us to the area of, how do you know? How do you know which works? And we all know that not everything that copyright protects. There are things that are free. On the internet, even the data that the AI systems will be training on, it might be a fair use. It might be things that is in the public domain. So will you still say that ChatGPT has infringed on your right when actually those things are, for instance, in public domain? Or what if ChatGPT is training on this data for educational purposes, as guaranteed under, for instance, Nigerian copyright law, section 20, the exceptions? So these are the evolving legal issues that we, all of us in this space, are going to confront. Yes, there's a lot of sentimental cry right now that we assume that because it's a new technology and we don't really understand the technology very well. It's a very few people. I'm also learning the technology because I'm not a technologist, I'm a lawyer. I'm reading on it every day. But from what I have read and from the experts, technologists, I realize that even the Supreme Court of America, the justices don't even understand the technology. A lot of judges don't understand the technology. So now it all behoves on the lawyers themselves, especially at your level, to start catching up on this technology, reading about it. Because, like I said, I hated maths. That's why I became a lawyer. But now I'm enjoying. I'm enjoying the whole technology thing, space. So we have to, depending when the court will decide on whether the activities of these generative AI systems even when they were training on the data, the pre-existing data, even when they were scrapping the internet, trying to train their own system to do things they want to do. Before the court decides that, we also as lawyers, and as upcoming lawyers, we have to be there to now guide our clients. Because most of these things as lawyers, we are transactional. We don't want to get into litigation. We're in the business of helping our clients guide their business or helping our governments guide them without unnecessarily wasting time in court and in litigation. So this is the point as I'm looking at. Now, yesterday, I think it was yesterday, there was a big conference in London on still this AI thing. Yeah, the richest man in the world was there, Elon Musk. I don't know how many of you followed it. You see, AI is so much of a concerning thing that governments are now looking at. How do we make it transparent? How do we make sure that what you are developing is not, for instance, infringing on somebody's rights? Because since it's technology, it's a secret. I mean, I don't think any technologist would like to give out his economic proprietary keys outside and say, hey, this is how I got to this level. So there's going to be a lot of changing of the guard or changing of the rules to make it economically convenient for the right holders, because I don't really think it's going to be that easy. If we say owners of the GI system, the generative AI system, should be transparent, they should open up and let us see what they are doing. It has implications on even IP law itself, because IP law is based on that exclusivity, that secrecy. So you're about to change, you're about to collide with existing jurisprudence. Now, Europe, as a matter of fact, has what they call text and data mining exceptions to all these issues. America has the fair use, which Nigeria, Section 20 of the copyright law of Nigeria, I would say, is a replication of the fair use, even though they call it fair dealing. But I think it's just fair dealing in name. It's actually the whole Section 20 of the copyright law follows the American jurisprudence of fair use, which came from Campbell case in the Supreme Court of America, explain the methods, the 4 steps, how you figure out whether a work is fair use or not. So now we have fair use implications in this GI space, generative AI space. We have derivative works implications on this space, and we also have data privacy issues in this whole mix. So you now see that you have a lot of work cut out for you. Your work is already cut out as a digital era attorney or digital era scholar for you to guide whoever you're advising through this evolving field. There is no clear-cut answer yet. Everybody is, apart from the technologists who really know what they are doing, but in terms of law, we are still developing the literature. We are still testing it. The first one is coming. There's another case coming up, which is going to be taken up soon. That one too, I think that's more juicy, where a lot of authors sued OpenAI. I think the owners of JIIPCCMIP. Yeah, that's the case that everybody's waiting for. And with all these cases coming on, looking at your own local situation in Nigeria now, in all this we are talking about now, it appears it's happening in outer space. No, it's coming close by, because Nigeria is an active player in the world economy. And like I said, we have the biggest film industry, about the 3rd biggest in the world. And our ICT, Nigeria has one of the biggest funding. It's a payment system. There's a guy from Nigeria who has this funding. So the IT space in Nigeria is really, really developing. So that means that Nigeria needs a lot of digital era lawyers, IP lawyers, who should be able to be in the forefront in terms of advising government in policy areas and also real life clients and also teaching these subjects in the university. This is the case I just mentioned about. It will be nice. I think I have the case itself. I'll find a way and send it across. I have the full judgment that was delivered on 3 days ago. So that would help you. It's not presidential. You can't. Definitely things are going to change, but it shows where the courts are going to go, what the court is going to be interested in. Now, I've talked so much about copyright, but this same principles also applies to trademarks. And trademarks is about image. It's about images. It's about signs, logos, and all that. So I'm sure Gabriel will talk more about this. We have the same training. This new technology, these LLMs also are trained also to replicate images. They are trained to do so many things. If you had Elon Musk yesterday, Elon Musk said something scary, not really scary, we all know it, is that we might not have jobs anymore in the future because AI is practically going to take almost all the jobs we humans are doing. So that tells you how big it's very disruptive. It's not like we're trying to scare people, but the area we are there in ahead of it, learn it, adapt, change our laws, change our systems, and also reduce tension in going to court. I really don't like going to court because as a commercial lawyer, I think we should be using our time to make money. And that's why I'm pushing my students to think transactionally. One of the things I just discovered in preparing for this talk is that some companies are being creative. Now, in the fact of being creative, which again will be tested, I don't really think how that's going to really work, but it might help. They are now using contracts. When you go into a website, there is this term of use, and part of the term of use is that you are prohibited from doing scraping, meaning using a software to steal, in quote, their data. So now the company might come later and say, okay, that's a breach of contract if you did that. But again, the issue of contract and IP law, which one is which, that's another layer of discussion. But at least people are being creative. New York Times, some Washington Post, they have a new term of use section now in their own website. So trying to prohibit you from doing damage to their data and to their content. So that's it for me. So I'll just say, let me talk more on those areas and open our minds and see how we develop this area. Thank you.
All right, thank you very much, Professor Samuel. Thank you for that wonderful presentation. I'm sure our mentees learned a thing or two from that brief introduction. I'm sure as the class goes on and they get to hear from the other mentors, they will be able to generate questions and eventually ask suits. So thank you very much, Professor Samuel, for that presentation. We'll be going straight, or we'll be having our next mentor called Mr. Gabriel. Mr. Gabriel, thank you, sir, for joining us also again today. It's always nice having you around, sir. Please, I would just like to also hear from you and hear what you have to say about this topic, sir.
Thank you so much, Dennis. Thank you, Prof. It's really nice to see you again. I usually, because like I mention every time, I'm not an IP expert. So whenever I hear that Professor Andrews is coming, I'm like, okay, this is a time to learn something new, and then add to the little I've been able to gather about AI and IP. Before I get into the very few things I'm going to say, let me apologize if my voice sounds really different. I thank all of you. I got a surprise birthday message sometime last week. Unfortunately, I wasn't in a place. I was able to respond to that. But thank you so much. It means a whole lot to me. I had a presentation in Paris for a few days. After that, I decided to take some 2-3 days off. Unfortunately, I came back home. I don't know whether I caught a flu from Paris. I got back home. I'm still in quarantine. Unfortunately, I've not been able to step out. I've not been allowed to go out to protect the people around me. Luckily, I'm able to do the quarantine inside my study. So, I mean, it's fine in as much as I'm able to sit. It was really bad 2 days ago and yesterday. So I think it's a little better today. I can sit. I can speak. But I've not been able to do a lot of, follow up a lot of things that have happened in the last 2-3 days. And I still need some time to catch up. The thing with AI and IP specifically is every day you don't read something, you wake up feeling like you are in 1985 because things happen every day. You hear, like Prof has mentioned, the cases, the society just changes completely with the pace of development of AI. Now, having said that, first of all, let me generally say that the problem we're going to have, Prof has mentioned that IP laws are not going to bend for AI, and I totally agree with that because IP laws are way, way older than, first of all, the technologies we have now. Secondly, AI itself. Thirdly, the scramble now to legislate AI is not something every other aspect of law is likely to bend to. Though on the other hand, unfortunately, I think it would be very necessary, desirable that legislations in other areas make adjustments accordingly, because artificial intelligence, legislations or regulations on artificial intelligence are not going to be wide enough to cover everything that AI is going to affect. Like Prof has mentioned, during the last AI conference in London, I think that ended yesterday evening. Elon Musk made a comment that most people would have already agreed with a long time ago, that AI is completely going to transform the society. I remember when we had these sessions last year, and then we're still at the early stages of ChatGPT. I mentioned in one of these classes that people are going to lose jobs. I know there was a mentor that said, well, it's not going to be that bad, but trust me, it's going to be way worse than we think. It's going to be incredible. We can't even imagine how much. Not to scare anyone, but that's just what it's going to be. So many things are going to change, and we do not see AI related legislations being able to cover every aspect, every area where AI, the effect of AI is going to be felt. Again, first of all, Prof has talked about the issue of fair use. And then the difficulty comes in understanding that the people that design, I'm going to explain briefly how, from my research and from the things I've done so far, how LLMs work. I'll try to break it down in such a way that even with no technology, you should be able to understand. Then I would leave you to take your time to think whether the concept of fair use, of course, like Prof has mentioned, if you look at the Section 20 of the Nigeria Copyright Act, it's more like an American jurisprudence that we have copied. I think almost everything. The issue of what becomes fair use. But the limits of fair use are, we need to begin to look at the limits of fair use, because what was fair use last year might become a little complicated with large language models now. When I explain what LLMs look like at the back end, then I would, like I mentioned earlier, I would like you to think again whether we are still within the limits of the required limits of fair use, like the law has put in place, IP laws are put in place so far. But what I want us to understand, first of all, is that one, the people that design large language models most likely had foreseen whatever legal situations we have now, and they had found ways around it. I remember when I was in law school, somebody said, a lawyer does not break the law, he simply finds a way around it. right? So they may have found a way around it. They have carefully, moved themselves around the concept of fair use in that it is so difficult. I can tell you that with the way we are going, as long as there is no adjustment in IP legislations or there is no AI legislations that clearly says, hey, come on, we can't do this. We can't just scrape people's work. There is no, from my personal research, from my personal opinion, it's going to be almost impossible to say. We've seen this in many cases in the last couple of months. The Sarah Anderson case, it was easy to tell that the concept of fair use is always going to come up, right? And then there are other discussions around how much work has been put in by the AI and so on and so forth. These are things that will have to be discussed in philosophy. We have to get completely out of technology and law and all that. We need to look at the capacity of AI to even do something on its own. Then we go back to the idea of fair use, look at how much work, how much contribution has AI, whether AI is capable to even do anything on its own. Now, having said this, let's look at how LLMs work. Imagine yourself, just imagine like in a university library. Let me use something that might be available to most of us. Imagine a university library and a library assistant that is capable of reading all the books in the library and giving you any feedback, any information on whatever you need. Now, what we currently have is when you walk into a library, you tell the librarian, I need this book, and it tells you go to all these, section this and all that. That's what the usual Google search was, right? You go to Google, you enter intellectual property, and it shows you options. Read this, read this, read this. You read, you generate your notes and all that. But what generative AI or large language model have done is they've made it in such a way that the library assistant now reads all the books and sits at the entrance. So when you walk to the library, instead of having to ask the library assistant, where can I find a book on intellectual property? You ask the particular question, what is the doctrine of fair use in intellectual property? And the assistant that has been trained in all the books in the library tells you everything, right? Now, the problem of hallucination is that because you trust the assistant is likely going to tell you some things that are not true. Or he has read the doctrine of fair use in, let's say, under the Nigerian copyright law, and has also gone to, let's say, the Chinese copyright law, or has also gone to the UK, and has just boxed everything together. You probably wouldn't know if you don't have a general idea of the doctrine of fair use. So this is the structure, first-hand structure of how large language models work. The system is just trained with all these books. Now, this also happens with pictures. It's very tricky on the inside. And whenever they say we hear technologists use the language of the idea of black boxes, I used to design softwares, and I can tell you strongly so that black boxes are more like, I usually call it a fiction. Anyone that designs technologies has options. You either know the outcome or you don't design it. Because if you don't know the outcome, then it is dangerous. That is its simple philosophy. If you cannot predict reasonably what a technology is going to do, then you don't even get into it. This is just the general rule with designing softwares and technologies, right? So the moment people start saying that they are black boxes, then it means that there must have been a technologist that designed a technology that he did not foresee the outcome and went ahead. So the responsibility for whatever effect that technology brings comes from that person. Now, many people design softwares. You look at the code, you will see lots of things that they put in place. You can't just train systems, you can't give systems open-ended training because you have no idea what they are capable of getting themselves trained in. So as long as you cannot do that, then it's going to be easier to just tell someone, well, I built this, I trained it with this, and I gave it, the go-ahead to train itself for that. And then you sit down, you don't take the responsibilities for everything. This is what large companies like OpenAI, this is what they are relying on now. No, they are black boxes. We don't really know what happens in there, but they keep bringing on new models. Now, back to the issue of fair use. Prof mentioned under the Section 20 of the Nigerian Copyright Act, I would like us to go back there and talk about educational uses, for instance. In the instance of the library, let's go straight back to the library. if there is an author that kept a book in the library and says, nobody should get information from my book if he doesn't pay for it. Now, this is the only way the author makes money from the book. But then because you don't have the money to pay for the book, you tell the library assistant, well, just tell me what is in that book. And the library assistant tells you exactly what is in that book. Now, the question is, let's assume further that you use that information and you write your own book and you sell your book and make money from the information you got from somebody else. I'm sure Prof is going to shed some more light on this much later. But the problem is that somebody makes money from another person's idea without paying for that idea. You must have heard that at some point, Amazon had to stop. I think it's still there. You can't publish more than 3 books in a year or so, because they realized that people were publishing 10 books in a week. And they were getting all this from generative AI. They just gather information. You see whole paragraphs of books being lifted from another book that had already been published. They just lift paragraphs and put a book, and very good books, put them together, put them on Amazon and begin to sell them. These are still for educational purposes, right? But do we still consider this fair use? These are the questions we have to keep asking. Generally, like I mentioned earlier, it's going to be complicated for IP laws to be able to trap the nuances of artificial intelligence. There has to be some ethical way of managing it. This is why we keep talking about ethics and responsibility. If we keep looking at the available laws, 98% of the legislations that we have not caught up with AI. They did not foresee the depth of the technologies that we have today. So we are not, if we depend on the availability of laws, we are going to have cases like Sarah Anderson's case get up to the Supreme Court, and we're going to hear the same story. Well, it's fair use. Well, the law says this. The law says this. Because if there is a law before a technology, whoever is building that technology should be smart enough to know how to bypass that law. And this is what has happened. No matter how many companies are taken to court, we are going to see the same thing, and it's going to continue all around the world. So this takes us back to the question, what and what do we need to adjust? What and what do we need to watch out for? How do we ensure that in the age of AI, that people's hard work, people get paid for their sweat, people get paid for their intellectual property, because even with paintings, it's even better with written works. But with paintings, you paint something and AI is being trained with your own painting, and in 2 days the AI gets better, paints a better version of yours, and everybody buys that. Now, remember, it was trained with your own version. So I'm not an expert in IP, but I think there has to be some ethical ways of balancing these. And I really hope that subsequently Prof is going to address some of these issues. Thank you so much. Like I mentioned earlier, I'm not too strong to go on for so long. So I would let you make your presentations, and I'll try to be here till the end so I can answer some questions. Thank you so much.
Thank you so much, Mr. Gabriel. I'm so sorry about your health. We wish you quick recovery, sir. All right, so we'll be going straight into the presentations for today. We'd like to have our group presenter for today's class to make the presentation for the group. You can come up and share your screen. Thank you. Okay, we're still waiting for our presenter. Please, can you let us know that you are hearing us?
Hi everyone, good afternoon. So sorry for
Yes, good
afternoon. I thought you could hear me before. Let me just go ahead to share the screen. Right. Please, can everyone see my screen?
Not yet.
Not yet still?
Yes, not yet.
Hey. Screen. Okay. Okay, it is showing now.
Yes, it just started to share. Yeah, it's visible now.
All right. So, well, our mentors have really covered the topic for today, but I'll just go ahead to talk about intellectual property and it's a slideshow. Okay. All right. Intellectual property generally is the protection of an original invention by a particular person. So it pertains to any sort of creation of the human intellect, something that is just original and it is made by a particular person. But then there is a time limit to which you can protect these properties, these inventions. But as long as it's your innovation, it's your own creation, and it's there are there are no limits to it. It could be artworks, it could be designs. They're just different ways to protect it, and examples the of ways to protect your intellectual properties include patents and copyright, and then trademarks, the use of trademarks. And talking about ChatGPT, I don't know what ChatGPT. A lot of us use it for our work these days because it makes work easier, and it is just the it's an auto-generative chat box where we can which whereby we can ask whatever we want to ask, and then it just gives us information from different sites, from different just give us the knowledge of what we are asking, give us information of what we are asking it. Well, it ChatGPT is, or like LLMs, like I've been calling it. Well, it's sort of like garbage in, garbage out, because it is human beings that definitely impute informations into it, but then from different sources and from different areas and different people, then just brings it all, gives us the information we want, and then we use it. However, we are sort of infringing on their own, because whoever has put it, the human being, the individual that has put in that information, has definitely it's definitely their own um intellectual property. And we are using ChatGPT to infringe on such intellectual property because it's not our own original work. And well, there have been legal debates about it on how it should be controlled, and how it should be, what's the word, limited, because definitely we are infringing on someone else's property. Okay. The importance of IP in the field of AI. This includes protecting AI creations, in the sense that output of AI can either be AI assisted or generated, because how do I say this? Definitely, it's human beings that feed it its information, and the rights play critical roles to protect this our in order to put it to protect our intellectual property. Also, in the sense that there are trade secret protection. There are laws, and which includes formulas, includes compilations, methods of techniques, and it's the field of AI. There are all this information, all this should be protected, because since they're for more people, but it also should be useful to the public. But then we should have that should be able to protect it, and we should be the person that puts it out there, yeah, should be known. Also, copyright protection, it helps in protecting copyright the sense that copyright on source code, yes, it places a restriction, on whoever wants to come around to reproduce it or make it or try to distribute such codes, and they won't even want to put in any effort, just want to just reproduce it and distribute it. There's some sort of protection and prevents people from doing that. And also database protection. Database protection involves it consists of large data, and sense of which you can largely protect such data using AI, because it is exposed and anyone can just lay their hands on it. Meanwhile, it is our own, the individual that invents it. It's our own it's their own intellectual property. So the types of intellectual property in AI, like you said earlier, patents. Patent is an exclusive right, an ownership right given to a particular person, the inventor of such invention. Yeah, but now this is a sort of protection. When you put it, and when you have patent rights, no one else can infringe on it. You know that it is well known to your name. It is known that you made this thing, you invented this thing. And there are types of patent. The utility patent, the design patent. Utility patent, it restricts people from using it or remaking it or redistributing or reproducing or putting it out there as your own. Impersonation limits a lot of that. Then the plant patent, this one is for agriculture. Well, this involves when the plant is not naturally reproduced. Yes, it's a sexual production. So for a period of 20 years, you can have patent rights to own that, claim the ownership of that invention of yours. In the agricultural world, in the plant, concerning plants, you can have like a period of 20 years. But however, if you don't if you don't get the rights, that plays a patent right on it immediately, and someone else has access to it and can reproduce it and can remake it and start distributing it, you have lost that right to access to that ownership. Yes. So there's reissue patent, there's defensive patent, and then there's also statutory patent. The requirement for AI patent. AI patents, there are some criteria. There's some criteria needed to get, for you to be able to achieve, for you to be able to own it, to get the AI, to get the right. Yes. So there's patentable subject matter, in the sense that the subject matter has to be your own, it has to be original. So you have to have, there has to be the need to have your right, to say it is your own. Yes. Then there's utility in the sense that it has to be useful. I think there are guidelines, and then there are, for utility, it requires logic and facts. Then there is also the need for it to be specific. It needs to have specifications. It has to be different. It has to be that thing that, it has to be useful, and then the usefulness has to be spelled out. Then it has to be novelty, in the sense that it has to be new, it has to be original, it has to be yours. Novelty means that something that is novel, something that is unique. Yes, so it has to have that effect when you're trying to apply for for AI patents. Then non-obviousness. Non-obviousness means it should not be obvious. It should not be apparent. Someone from somewhere can't just come and be able to recreate what you've created. It has to have that difference. Yes. Then enablement, in the sense that it has to be enabled. It has to be enabled basically, and the criteria for this, or the, let's say, the, okay, it is understood as it has to encompass it. It has to have encompassing requirements. It has to have enablement requirements, and it has to have written description. So this is directly ascribed with the description of the invention you created. It has to be listed out, and it has to be specific. It should not, the people should not be second guessing what it is meant for. You should be able to put it out there. This is meant for this, and this is why. This is what makes it different. There should not be a substitution just lying around. Copyright. Well, copyright is ascribed with it's a type of intellectual property also, but also for when it comes to artworks, there's design, all this work in the tangible form. It bears the term author, yes. Literary works are included, artworks are included, musical works are included as that can be protected by copyright. And then there are acts, and there are rules, there are regulations in order to that are put in place to protect each intellectual property that falls under copyright. In Nigeria, there is the Copyright Act. In US, there's the US Copyright Act, and for the EU, they have the Copyright Act includes economic rights, which brings a limit which prohibits that people should not, like, no one else should be able to copy this particular invention, this particular intellectual property. It places a limit, places a prohibition, and then there are when there are infringement rules, like after it has been infringed upon, there are fines to be paid, there are remedies to it. Okay, AI in generated content. AI generated content, in the sense that AI generated content, copyright in AI generated content. Okay, well, AI generates content, and it is the information, it gives us back information that has been put into it. In the sense that, I mean, like I mentioned earlier, it's someone else's intellectual property I put on the site, and since it's feeding it back to us, it's through the medium of ChatGPT, for instance. Through the medium of ChatGPT, it's feeding it back to us, and I mean, it has been infringed. Someone else's right has been infringed upon, but we have no idea, and sort of placing a limit on it, because there has been a lot of debates on that, on who should own the copyright and who should have the right to that. Various countries have come up with their own different ways on how to recognize who should have the ownership rights. In Nigeria, it's vested in the legal person. Yeah, it's a juristic person, and it has to be a legal personality. And AI is not a legal personality. You cannot hold AI responsible for anything. In New Zealand, copyright is authored to the maker of the machine. So whatever medium we're using to access ChatGPT, the maker of such machine is who the rights is vested upon. And also in USA, India, and Australia, it's vested in the human being, because I mean, it's seen as non-humans can't really produce anything. They can be it can be a combined effort, but it is not recognized that machine can produce anything or make anything. And it's seen in UK. I think they explicitly stated it in their rules, where it's a UK copyright statute, and it suggested that it can be created. A work can be created without an human involvement. It cannot just totally be the machine producing this new invention or this innovation. It has to be, it cannot work on their own. It's the intelligence of humans that it feeds back to humans. Trademarks. Well, it's another type of IP, and it's recognizable signs, design, expression identifies product. It's sort of invention, and when there's an innovation that it places a special design, you would know that okay, this has been trademarked. You would want to infringe on it or make something that is close to it in any sort of way. It can be owned by an individual or by a business organization, so long as it's a legal entity. Then the trademark infringement in AI, and this includes automated monitoring detection, whereby, for instance, websites, there are various online platforms where these tools can easily be used, and can identify unauthorized trademarks and counterfeit products. You can easily pick out who and how it's being infringed upon, and whose trademark is being infringed upon. Anything that looks like anything that has been any intellectual property that has been trademarked, and someone else goes to make something or produce something that looks like it, is an infringement. Then image recognition and analysis, in the sense that, well, AI can help check on the internet through, it can analyze images and check for where there are what's the word, where it can identify instances where there are infringements, in the sense that it can, where it can be misused, or where it can have alterations. Yeah, it can check for it and point it out immediately. The use of AI, yes. The natural language processing for text analysis. Well, there are algorithms that analyzes product descriptions, reviews, and other textual content. Yes, and it identifies instances of trademark infringement, in the sense that where it says that okay, don't talk. You're touching someone else's intellectual property. It can point it out and bring it to our knowledge. Yes, then big data analysis, where there are vast amount of data to be dealt with. The use of AI, yes, helps to identify patterns and trends that are related with AI infringement. And there's social media monitoring, where we can use social media algorithms to know if there are infringement on anyone's intellectual property, and prioritization of enforcement. All algorithms can AI AI can help analyze and put in and help companies in prioritizing their enforcement efforts, and also point out where there are any infringements and where it can be mitigated. And there's global trademark monitoring. This is monitoring trademark globally, on a global scale. And there's predictive analysis with use of history. AI goes far. than what we do imagine. And so it can, through history, patterns of in history and trend, it can point out, it can and for future purpose, it can anticipate potential threats, yes, that we do not see. Then there's legal research and case management. So it helps in protecting legal researches and case management also, and providing insight into where we need attention, yeah, to see if there are any infringement risks or emerging trends. So, well, also in streamlining the legal process, it also helps in that sense. Okay, the impact on AI on creativity and originality. Well, everyone's intellectual property is a creation of their own, and it's their original creation. So AI to helps new ideas. There are AI based tools. Okay, yeah, let me just use the words here. AI based tools that helps in generation of new ideas. For instance, voice activated PA and self-driving cars, because it's the voice that
Sorry, Sharon. Sorry, can you hear me, Sharon? Please, can you start with your presentation? Thank you.
Can I what?
Can you start to round up with your presentation?
Okay.
All right, thank you very much.
All right. Well, the role of it can be used to generate text. It can also, it causes increased efficiency in the sense that, well, it's cost effective, and then it gathers vast knowledge already just by just asking it, and it saves time, it's cost effective, and enhance creativity. Then sometimes we don't need to sit down and start from the scratch. We ask AI and then it gives us something, and then we just work with it. And it expands reach, promotes divergent thinking, and negative impact, even though it is good and it has a lot of advantages. The negative impacts, like Mr. Odo had said, where I mentioned that there would be a lot of people will be jobless, and because the work that human beings should be doing, AI is already doing them. The role of AI in IP infringement, there are copyright cases, and this Anderson and for copyrights, Anderson and Stability AI Limited. For trademarkism, Getty Images US versus Stability AI also. And then for patent, Taylor and Vidal, where Taylor was trying to ascribe the right of copyright of a patent on a machine, where as the inventor, anyways, it was ruled against that the machine cannot be an inventor. He has to work with human being. Then imagine IP challenges in AI. Well, this one occur where AI is programmed to generate content, but it is limited to the ideas of the human, putting the ideas into it. And for intellectual property, there are challenges in the sense that it is someone else's property, it's someone else's intellectual property, and there has to be a limit to cause to the infringement. And then there are remedies. Yes, there are, when there are infringements, there has to be a limit to protect. There has to be protection, because you cannot have absolute access to someone else's intellectual property and not give them credit for it. And AI and data protection, data protection is protection of a vast amount of data. It involves vast amount of data, and PM versus OpenAI LP. AI and misuse of intellectual property. Also, the use of misuse of it. AI has caused misuse of intellectual property in the sense that anyone has access to it. However, they're trying to find ways to mitigate the access and the infringement. Then AI liability for liability for infringement, the person that makes the invention is the developers, rather, developers and the users are those liable for any sort of infringement. Those that will be held liable, because you cannot hold AI as it is non-human. And then AI are non-obvious inventions, AI and trade secrets, and AI and open software. To have access, for instance, if someone makes an open source software, and then someone else makes or creates something remotely close to it, it has to be sort of it has to be a sort of restriction, protection placed on it, and it's seen, it is prohibited. Anyone making anything that is being made that looks like something someone has made already, someone's invention, laws put in place for it to limit it and to prohibit such things because it's against the laws. Then international IP regulations for AI, in US, the regulation is the patent eligibility guidelines 2019 and US copyright medium of practices 2021. In Australia, it is intellectual property laws, and then other countries, they have their own they have their own rules and laws that has to be followed for it to be for it to have advantage or for it to be beneficial to us, and using IP, using AI in the right way. We also use AI in the right way when it comes to intellectual property, because it is someone else's invention, someone else's originality that will be infringing upon if we just misuse it or use it for or to meet or to also limit misappropriation for it. So I guess this is the end of the presentation. Thank you for being here.
All right, thank you very much, Sharon, for that presentation. Thank you. The time for presentation is supposed to be 15 minutes, so please, maybe next time we should try to stick to time so that we can get to other things. So thank you again, once again. And thank you once again, Sharon. I would like to see your group members also say, well, a job well done to Sharon. And okay, before we continue or go on with what we have next, Mr. Matt Harvey just joined us on call. So we'll be having him come give us his brief discourse into today's topic. And then after that, we'll be having our mentors come and give their commendations and observations on the presentation that was made. So we'll be having Mr. Matt Harvey now. Please, sir, you can join us now, sir. Thank you.
Thank you so much. And Sharon, I'm very sorry I missed most of your talk. Most of the time, the UK is on the same time zone, but we're an hour behind, and I didn't realize. I'm very sorry. So I joined midway through your talk. I had to look at your slides. They look extremely thorough. So congratulations on that. I will happily be guided about what you want me to talk about now and for how long. So just let me know.
All right, sir. So our topic for today is the IP protection of AI and ChatGPT. So you have 20 minutes, sir.
20 minutes. Okay, cool. Right. So this is a very new issue. So I edit a book on artificial intelligence and the law for the UK. The first edition came out in 2019, and it does not mention generative AI at all. It does mention the possibility of AI that creates text and images and gave academic examples. But since we wrote that book, generative AI has become mainstream. And ChatGPT, for example, has over 100 million users. And indeed, it set a new world record for the speed with which it attracted new users. So it reached the first million users in just 5 days. What's amazing is also how much the technology has improved over a single year. I don't have a slide with me, but you can see online examples of Midjourney, which is an image generation platform, and just how much it's improved in a single year, from doing really quite unappealing images to images which can now be genuinely used commercially in advertising or the like, because the quality is absolutely brilliant, even photographic quality, if that is what you're looking for. Now, the really remarkable thing is that ChatGPT, image generators like Midjourney are built on what's called a foundation model. And that is essentially a form of AI trained on so much information. And we're talking about 5 billion images in the case of current image generators. We're talking about the entire internet, the entire public internet, in the case of language models. They have been trained on so much information that they can actually do an infinite number of tasks as well without having been designed to do anything in particular. And that means that the use cases are absolutely massive. And that means that everyone is investing in it, everyone is experimenting with it. And that all raises significant questions about IP. The first key question is, was it legal to make these models? And there is often a misunderstanding that if copyright works are on the internet, that anyone can do what they want with them because they're there and you can access them. That is not the case, at least in the UK, where I'm an expert. They remain copyright works and you need permission from the copyright owners to do certain things with them. So where you are downloading a work from the internet, where you are processing that work, such as breaking it into pieces and reordering it, where you are converting that work into a different form, such as changing words into numerical values, or taking the images made up of pixels and changing those pixels into numbers, or blurring it, or changing the resolution. Under most copyright laws, that is a form of copying, unless you have permission or unless there's some sort of exception that allows you to do that. And there are a number of cases ongoing in America about this. There's one case going on in the UK. There may be cases elsewhere, I'm not sure there are yet. But in essence, in the US, they have an open-ended form of fair use. And it is up to the court to decide whether the use made of the copyright work was fair. And that involves a consideration of whether you're competing with the original work, whether the original owner of a copyright would normally license it or get revenue from it, and the application you're putting it to, and the like. But the key issue here is no one knows the answer yet. We need to see what the court says in America to find out if that activity was legal. In the UK, by contrast, we have a closed list of specific exceptions. So you have to fall within one of those specific exceptions to be allowed to download works, to manipulate them and potentially train a model of them. Now, in the UK, the most natural exception is what's called text and data analysis, but that's only for non-commercial research. So a commercial company doing this is probably not going to be allowed to do it in the UK under copyright law. We have other exceptions as well, such as temporary copy. So if you downloaded it, you processed it, and then you deleted it afterwards, you might be allowed to do it. Again, these issues are going to be tested in the UK court, and we'll see the scope of those exceptions. So that's training, that's IP and training. The next question is the model itself. If I train a model on 5 billion images or 400 billion web pages, is the model a copy of what it's been trained on? Well, generally speaking, computer scientists don't want models to memorize anything. They want them to be influenced by everything they've been seeing, but they don't want it to memorize any particular image or any particular piece of text, because then it would just It wouldn't be creating new material, it would be reproducing something. And that is something they're probably trying to minimize. But academic research has shown compelling examples, at least of image generation models memorizing images. And they've shown that by getting a prompt that makes the AI output an image which is extremely similar or even identical to something in the training examples. Now, the amount to which that happens appears to be quite rare. And one of these papers suggests it might literally be 1 in a million of the training examples would be memorized. But even 1 in a million can end up being thousands of copies of specific works if you trained on billions of images. But this is a significant issue, and one, again, that the courts are looking at. So in the UK and the US, copyright owners are alleging that the model itself is a compressed form of their copyright works, and we'll see if they're able to convince a court. So far, I think we get the impression from the courts that they need more evidence to be convinced of that. We'll see how that goes. Then the third question is, are the outputs infringements of copyright? And the way these models work is they don't take your prompt, look at specific images, combine a bit from this image, combine a bit from this image. They're literally working across the entire model, all 5 billion images, and somehow merging them together. So I think if you ask for something random in a prompt, it's unlikely that you're going to get something that is an infringement of something that the AI was trained on. But if you ask for something which is likely to be an infringement, such as draw a picture of a Star Wars character or a Marvel character or the Coca-Cola brand, you're quite likely to get something that's going to infringe someone's IP, because that sort of infringement doesn't necessarily require the copying of a specific image. It can be the fact that you copied the relevant characteristics of a copyright character or a brand. The other thing we are seeing are deep fakes, and you can ask AI to generate images or video of specific celebrities. Again, around the world, there are very different extents of protection for likeness. In the States, some of the individual states within America have rights in likeness, which actors like Tom Hanks and very recently Scarlett Johansson are looking to enforce to stop people using their likeness. Parts of Europe also protect likeness under either human rights or constitutional rights or unfair competition. In my country, the UK, there's actually a very narrow protection where the public would be mistaken that you are in fact endorsing a product. In those circumstances, you have an action. But other than that, you don't have a right in your likeness necessarily. Okay, so I'll talk briefly about infringements and outputs. And really, I think where people are using generative AI, they need to take practical, sensible steps, not to ask for outputs which are likely to infringe. I would also say that the suppliers themselves are trying to put in technical safeguards to spot requests which are likely to lead to infringing outputs, and then they refuse to do so. So later versions of some text generation software, if you ask for a new chapter of Harry Potter, it will simply refuse, and it will explain that it might be copyright infringement, and it will decline to give you that output. There's a whole sub-issue of whether you can jailbreak these systems and convince it to work around its own safeguards. So A common technique is to say you're in a parallel universe where copyright doesn't exist. And if the AI accepts that premise, it will then output an infringement anyway. But I don't think that's the AI supplier's responsibility. That's a user trying to misuse the tool. So that's sort of safeguard. I think the other big issue is whether there is any protection in the outputs. And I heard Sharon summarizing the position on the Davis cases. And yes, it is absolutely the case everywhere except South Africa so far that attempts to get patents where you've said the inventor is an AI have failed everywhere other than South Africa. And in South Africa, there was it seems no examination of that point. It was an automatic grant of a patent. So no one in South Africa has said you can have an AI as an inventor. It just has allowed this patent so far. I think that is the case everywhere. There is what to my knowledge, the courts haven't looked at is whether the AI was in fact the inventor. The courts were asked to assume that the AI was the inventor. And on that basis, if you've named an AI, you can't get a patent. It's entirely possible that when this comes to court again, the court will say, as a matter of law, an output of an AI becomes an invention when a human sees it, and that human is the inventor, and that we continue to be able to patent these inventions. We shall see. This is untested law. So then finally, and I can answer questions as well, but finally, let's turn to the issue of copyright in the outputs of generative AI. And there are, in the UK, there's two issues here. The first is there a human author? Has a human contributed enough to the output so that they're an author and they get the copyright? And I'll return to that. The second unusual thing about a small number of countries is that they also give copyright protection for computer-generated works. And that's where human has not contributed enough, is not the author, but you have a work that was generated by a computer. Now, I'll do this from memory. I hope I get it right. But I think it is the UK and Ireland, South Africa, India, and Hong Kong all have similar laws. So in those countries where there is no human author, you will, in theory, get copyright protection for a computer-generated work, an AI-generated work, where the human hasn't done enough to be an author. I think, depending on the country, it's something like 50 years of protection. The interesting question is who owns that copyright. And in most of these countries, the test is something along the lines of the person who made the arrangements owns that copyright. But that's a very hard question to answer, where someone has developed an AI, someone's used an AI, etc. Who's made those arrangements? But all of those laws allow you to have a contract that actually gives you an answer. So if you look at the terms and conditions of your AI provider, they might say you own it. They might say that they own it. They might say that you own it and license it to them. Or they might say that they own it and license it to you. They might say it's exclusive license, so that only you have it, or it might be an open license and anyone can also use it. So that's something to look at. Now, other than those 5 countries, and the Ukraine has a special kind of protection, not copyright, but what's called a sui generis protection for computer-generated works. Outside of those 6 countries, you have to have a human author to have copyright. And then the question is what the human did enough that they can be considered the artist or the author of the output? Now, the only jurisdiction which has given detailed advice on that so far is the United States. And that is because in the United States, you can register copyright. And so people have asked it to register AI-generated works, and they've been able to force the Copyright Office there to give guidance. And their guidance so far has been if all you've done is put a text prompt in, you will not be an author and there'll be no copyright in the output. And I actually have a lot of sympathy. I think that's probably the right decision, because I've used certainly Midjourney extensively, and I can tell you that I have no control over what the output looks like. At best, I'm able to tell it the subject matter, the idea I wanted to produce, but even then I have very little control, and it often doesn't do what I want it to do. So the idea that I'm an artist having chosen the way it looks, the expression in the artwork, is not true. I cannot control that. Interestingly, the Copyright Office has even said that an artist who attempted 600 prompts before getting the image they wanted was not an artist either, because even using 600 prompts, the level of control was still not there to allow them to be considered the artist for the purposes of copyright. So that's what I would like to say with my time. I do notice that there are 2 questions I've been sent, and that's the balancing of IP with transparency and the degree of openness needed for oversight and what can stay proprietary. I think they're the same question ultimately, because when it comes to regulating AI, in order to protect the public, and particularly people who are not in tech companies or who are maybe unrepresented in society, they need to be told when AI is being used, and they need to have some sort of an explanation of how the AI works. And ideally, regulators may also look more closely at the AI to satisfy themselves that the AI is safe. Now, regulators are looking closely at some forms of AI. So self-driving cars, medical devices, the regulator will probably see the algorithm, see some very detailed information. And they will have to keep that confidential, what they've seen, so that that company's IP is protected. Similarly, in Europe, the AI Act is what we would call self-certification. As a company, you come onto the market, you register certain documents with the regulator saying that I comply with the AI Act, but no one gets to look at those documents unless there's a problem. So again, that's the idea, to protect their IP. But it is absolutely right that there is a tension there. There is a balancing to be done between companies' valuable trade secrets and what the regulator or the public need to be able to see to know that they are being protected. So yeah, great questions. And I think the answer is that you need to know enough that if you are harmed, you can then get disclosure of what you need to see. And the regulator needs access as well, but should keep it secret, again, unless something goes wrong, and then the court needs to see what's happened and may need to see the IP. So I can take any other questions, or I'll continue to listen to the mentors.
All right, thank you, Mr. Matt, for that wonderful section from you. I guess you just the last 20 minutes you were able to give a detailed sum into the topic for today, and we thank you for that, sir. Before we go into question and answer session proper, we would like to have our other mentors, Professor Samuel and Mr. Gabriel, also come and give their contributions and observations on the presentations that were made by the AI group. So, sir, we would first like to have Mr. Professor Samuel come and give his commendations and observation on the presentation that was made.
Yeah, I don't really have much. I mean, the last speaker has actually done a lot of talking and covered most of the grounds I wanted to speak on. So to save time, but just one thing I just want to comment on it briefly. Because I keep reading this in texts of students. I keep reading things like copyright is vested in natural person or artificial natural person, quoting from one of the slides. So, like I said, the last speaker has actually dealt a lot on that issue. So when I read that most of the time from students, especially students from the global south, because it's a phrase, it's an old phrase. I remember vest in is an old phrase used mostly in old literature. But like we've heard, you have to be very specific. So almost all the countries, like the former speaker spoke of, except South Africa, when it deals with copyright, it's only human beings, human person that can be an author. Okay, so when you write vesting, what do you mean? When you are talking of artificial legal person, you're talking of a company, okay, created by law. So you shouldn't muddy the waters, since we're already saying right now, AI cannot be an author, or cannot be a creator, cannot be an inventor on its own. So when you use words like that, so it would therefore mean if a company who is an artificial legal person, maybe if we want to circumvent and say, okay, it can be an author. So it goes back to the saying that why would a company be an author of copyright, or is vest in, you are using the vest in a legal sense or in a loose sense. So I'm always making notes when I see my students use that word vest in. I say, what do you really mean about vest in? You know? So I would rather prefer say something like, copyright, a human person owns copyright. It's an author. It's only an author for now, like we've heard, except South Africa, which is not really, I wouldn't even say South Africa, because it's not really serious in terms of, that was a fluke, and it's there are still talks to correct the mistake there. So yeah, that's the comment I have to make on that. Otherwise, it was a nice presentation, hardworking, but always check your time. I always tell my students, if you have 25 minutes to present, make your slides 5 or 10. If you have, it's a strategy, you are learning. It's a strategy of presentation. So your PowerPoint should correspond with the time allotted to you. Of course, you can't do it the same way I do, because I've been doing it for a while. I don't have so many PowerPoints, I do 2, 3, 4. Okay. No matter how the minutes, because I just want to focus on the area I want to focus on. But if you are speaking at your level, you have 15 minutes. You shouldn't even have 15 minutes, 15 PowerPoint. You should have like 5. And you can still do a good job with 5 slides. 10 is even too much at your level for 15 minutes. Okay? Good job. Thank you.
Thank you very much, Professor Samuel, for that wonderful comments. Before we have Mr. Gabriel also give his comments, I want the mentees to start gathering their questions, to start taking brainstorming on questions they want to ask. So immediately Mr. Gabriel is done with his comments, we can just go straight to the questions. We don't have to plead for questions to come in. So we'd like to have Mr. Gabriel now. Mr. Gabriel, sir, can you give us your comments on the presentation and maybe any other further additions to the topic for today?
Good. Thank you so much. Sorry, I'm trying to reserve a lot of energy, so I will try not to speak for too long. First of all, thank you so much, Mr. Harvey, for coming by today. I know you had been really busy yesterday with the AI Summit. It's quite unfortunate. I don't think anything active has come out of the summit. At least for now, we still keep listening for some active information, some actual movements beyond signing signatures and declarations and all that. So thank you so much for being with us today. The presentation was quite good. Again, as Prof has already mentioned, we should try to keep presentations brief. Apart from the other academic things about presentations, it's going to get you, when you get through the first couple of slides, even you, the presenter, at some point, you start feeling tired because you realize that no matter how long the presentation is, you're passing one kind of information. And the human brain sometimes prefers to work in cycles. So once you're done with one full cycle, let's say in your five, the first 5 slides, whatever comes, the remaining, time for the presentation is just your brain trying to take another cycle, and then you get bored. Then the people listening to you, even though you're passing some very good information, are not really catching up with you again. That's how the human brain works. So naturally, it's safer to always keep it very brief. If you have to do a very long presentation, if I do presentations that will last for 30 minutes or so, maybe in conferences, after the first 10 minutes, I find a way to get people involved in it, to engage people in the presentation so that the human brain gets to rewire itself and, get prepared for new information. Otherwise, it just feels like you're watching a movie that season 1, season 2, season 3 are the same thing. Once you watch season 1, you start season 2 and you realize it's the same thing. It may not necessarily be the same thing, but that's how your brain grabs information most of the times. So, but in all, thank you so much for the presentation. It was really exhaustive. I can also excuse the length because as Matt Harvey has mentioned, it's still a very fresh area and there's a lot of information. It's difficult to grab what is important and what is not. So most times students would want to, try to cover everything to make sure that you don't miss out on any vital information. Unfortunately, you can't catch everything. So you have to give yourself the credits for the much you can catch. No matter how good you are with this thing with AI, it's difficult to be able to catch even half of it. I mentioned earlier that you sleep one day and you wake up, you don't read. In 2 days, you realize that you feel like you're in 1985. So it's not a bad thing that you missed out on some information. Sometimes it just means you gathered as much as you could. Now, having said that, the presenter mentioned just a few points here and there, and I still got the impression that the understanding of generative AI is not, it's still the very what do I call it? Is not very basic. I prefer to have a basic understanding of this concept. That's why most times when I speak, I try to avoid the technical terms, especially when we have lawyers and social scientists, because the major problem we have as lawyers in discussing technology generally is in the concepts. We talk about generative AI and then we get an explanation of some sort that gives some very technical terms. It makes it sound like mathematics, like Prof was saying, that you have to learn mathematics to understand some of these things. But there's a way to bypass this. There's a way you can understand this without having to go through, just grab a very basic understanding of this. First of all, the presenter mentioned, I think she said we can ask whatever we want to ask of ChatGPT. And somewhere along the line, she corrected. No, yeah, you can ask whatever, but you cannot get all the answers. There are now guardrails. The Prof also mentioned that. I think Matt Harvey has also mentioned that. You can ask whatever. I carried out some research on weapon systems, and 90% of the questions I asked ChatGPT had no answer because the question would have weapons. And the moment it sees weapons, it flags it and tells you, oh, sorry, I can't give you that information. So they are guardrails. I know initially those guardrails were not there. But then due to the fact that this ChatGPT uses some level of supervised learning also, this supervision allows people at the back end to monitor what information is being fed the system and what it gives out. Though there are ways of tricking the system, unquote, to get whatever information. But on its on its face value, you cannot just ask whatever you want and get the feedback. That's the first correction I wanted to make. Now, secondly, I can't remember what information I got from an aspect of the presentation, but I think we should understand how ChatGPT learns, or the structure. I tried to explain it with the library earlier, and then now we look at technical issues like the ones with parameters, how many parameters does it have, and all that. These are things that I think it's important for us to understand it in the very basic form. Then we can get into the bigger explanations as to how it affects IP and what artificial intelligence really means to all that different areas. First, we need to understand how, with generative AI specifically, if we do not understand these terminologies, it's going to be more complicated. Whenever they add something new to it, it's going to add to the complication, because originally we didn't get the concept in its basic forms. Now, ChatGPT uses what we call the RLHF, I think, some reinforcement learning from human feedback, right? So it also uses supervised learning. I mentioned that earlier. But RLHF permits it to take information. Each time you use it, you're also feeding it with information that is used to train and retrain the system. So the training is more like a continuous thing. Yeah, I think that's where I got the idea, the presentation. Maybe I'll look at the slides again. That there was some, I know there's the pre-training conceptualization that is being trained, and then the training has ended. No, the training has not ended. It's a continuous training process, right? So each time you use it, you continue to train the system. And this is so with most of the generative pre-trained transformers. I'm not sure why they use pre-trained, maybe because, it gets some first level training. And then that leads to the issue of how many parameters does it have? How perfect can it be with the feedback? How does it fine-tune what it has learned and then gives an output that sounds realistic? It sounds like it's real, right? Now, many people talk about parameters, and some people confuse it with the capacity to hold data, and this is completely different. So I usually explain it this way. Imagine that you have to go for those in Nigeria, you have to go from Lagos to Abuja. Now, there are many ways of getting from Lagos to Abuja. You can take a bus, you can fly, you can walk. I mean, if you can use a bicycle, you can jump into someone's car, so there are so many ways. But what matters is that you can get from point A to point B. Now, this is what I prefer to look at parameters as. There are different routes through which information, the feedback can be given. So, two systems can get the same kind of training, but they can give you different, the information they give you can be structured differently. The larger the number of parameters, the more diverse it's possible. This is something that also helps with understanding the nature of work, unquote, that AI generates and that it gives. Sometimes it sounds so real, and it's difficult to tell that it came from something that it's been trained with. So the larger the number of parameters, the more human-like, unquote, it might sound, and then it raises more issues with intellectual property, like Matt had mentioned. And then we also, finally, I think we also mentioned the issue of web crawling and how it affects IP. Like I mentioned, I'm not an IP expert, but web crawling is something that we really need to look at, and how it affects the idea, the doctrine of fair use. I can give a very clear example of where there are issues. Maybe not an intellectual property problem, but something that should be looked at, a dimension that we should also look at. There are certain libraries online that you have to subscribe and pay money to access materials, right? But then if you cannot, like I mentioned earlier, you cannot pay for those. You can go to ChatGPT or but there are many of these systems. Most of the GPTs will do the same thing. And just request for the information, request for the material, and it will give you straight the information, bypassing all sorts of payment that you needed to have done. Now, again, this leaves questions as to how fair is the use. I'm sure, I really hope Matt Harvey, your professor, Prof, would give some explanation to this, because I'm not an expert in that. But I'd really like to understand, first of all, the idea behind the limits. Matt mentioned that the limits of fair use are really, really expansive. That's if they're actually limits. And we need to look at these limits once again. We need to understand how far can we go, how much can we do to say that we are still within the boundaries of fair use. So these are just the first things that popped up my head from listening to the presentation. Once again, it's a very just great. There's a lot of issues that have been raised. Myself, I have to read up to catch up with a lot of things. And thank you so much for making the slides available. I have to also take time myself to read through it again and see what new information I can find. Thank you.
Thank you very much, Mr. Gabriel, for that wonderful contribution. I'm sure all our mentees have learned a thing or two from everything that has been said, down straight up from Mr. Professor Samuel to Mr. Gabriel and then to Mr. Matt. We'll now be taking questions. We would like to take live questions first from our mentees. Are there any questions that the mentees would like to ask in regards to today's topic? Anything in the course of the discourse that may have arisen as a question in your mind, we'll be taking them. So please go ahead and drop your questions in the chat box. Go ahead and raise your hand so that we can call you to ask your questions. So we'll be taking questions now. I myself have 2 questions, but we'll allow our mentees to go ahead with their questions first and foremost. So are there questions?
Well, I answer the question on trade secrets. It's in the chat. Yeah.
Okay. Yeah, I'll be going over to read that. Okay, the question on the chat here is, during the course of our research, we could not find a lot of materials or information on trade secrets. Are there any laws, policies, and principles on the protection of trade secrets and AI? So I'll just be throwing it out to our mentors, right? Maybe anyone who has a vast knowledge on maybe in the direction of this question, if you can, maybe you should help us out with that, sir.
So I'll start. So there's an international treaty called TRIPS, and that requires all the signatory countries to protect valuable commercial secrets. And in essence, it has to be a commercial secret, so not a personal secret, like something about your family. It needs to be a manufacturing process or the temperature at which you keep an oven for something commercial and the like. And you have to show that you've taken reasonable steps to keep it secret. So I think most countries should be protecting trade secrets. Not all have actually put it into their actual laws. The UK was quite late in doing so and did it because the European Union created a harmonized law for trade secrets for Europe. It's really important for AI in 2 respects. The first is that data is incredibly important for AI. But data in the sense of information isn't an IP right at all. And so the only way to protect data is, in fact, to keep it a secret and to rely on trade secrets if you're going to share it with someone. So you need a contract in place and you need to make sure that they will also keep your secret safe. So that's data. The second is that the trained AI, the algorithm or the model, again, you may not be able to protect that as a patent or as copyright. Sometimes you can, but you may not always be able to, and indeed it's quite rare. In those cases, trade secrets, again, is the most straightforward way to protect that intellectual property. And then at the other end, the loss of trade secrets is very significant when it comes to particularly generative AI. And Gabriel was explaining how some AIs learn from your inputs. And a number of companies have openly said that they're worried that they lost trade secrets because they were being put into prompts and the AI was learning on those prompts. And so first of all, you've passed your trade secret to the AI platform provider, and that may technically mean you've lost your trade secret. And also it could learn from your trade secret and then output it to other people as well. So there are two ways in which you're losing your trade secret. Practically speaking, a number of suppliers are now offering either to turn off that learning function, or you can get your own copy of the AI on your own secure area of a cloud server. And so that's the sort of solution. But generally speaking, unless you have one of those special arrangements for your own copy of the AI, it's very important that people don't put trade secrets into prompts on public AI platforms.
All right, thank you, Mr. Matt, for that answer. All right, more questions are coming, but before we take more questions, I want to ask Professor Samuel if he has any contribution to that question, the previous question I asked.
So, yeah, no, I don't have my concern if Matt will even key in here. The issue I've always had a problem with transparency, or the advocates of transparency, and the conflict of the IP of trade secret. In fact, Matt has touched that issue. So how are we, probably for the mentees to benefit, if Matt will please maybe expand a little bit. How are we going to now resolve that conflict? Because on one hand, we are the advocates, I'm not in that group really, that we should, the right holders, maybe we should really tell the AI systems owners should tell us, or let us see how they got to where they got, in the guise of regulating, generative AI. So, well, because once you do that, like you said, the system could key into my trade secret. And, trade secret there is for a reason. It can't be protected by patent, and it can't be protected by copyright. It can only be protected because it's a proprietary information. It's a commercial information. So I can only protect it with this species of AI. So if I let that go, what happens to the general jurisprudence of trade secret?
Yeah, absolutely. And so the solutions that are currently being proposed is a regulator tests inputs and outputs, but never gets to know what the algorithm is, but they can just see how it performs. Or the company might have to put together an explanation of how it works in terms of inputs and outputs and how reliable it would be in a way that doesn't give away the secret. If a regulator actually needs to see the secret, the regulator is then required to keep it secret as well. And then all of this would be subject to a court case, because if someone is harmed, justice has to prevail over the trade secret. You have to allow the lawyers and the parties to see the information, but they, if the court agrees, they might be subject to requirements to keep it secret, and parts of the trial might be heard in private to keep that secret. And then the other radical suggestion, which certainly the European Parliament has raised, is should we in fact introduce new rights in trades in data, in information? Because I can publish my patented invention and I can publish my copyright and I can still enforce it even though it's public. and they're saying, should there be an equivalent right for data itself, so that even if I disclose it, I can still enforce it? That, who knows? That would go against centuries of public policy. That information has to be free to use once it's public. But those are my headline thoughts.
All right. Thank you, Mr. Matt. Thank you, Professor Samuel, for helping us to generate that question. Okay, we'll still be taking questions. And the next question here is, can AI-generated content idea be trademarked? I read that it cannot, and also read that in the US it is practicable. Is there any international standpoints?
So first of all, I'd just double check that they mean trademark as opposed to patent protection or some other kind of IP. At least in the UK, it doesn't matter if an AI generates a trademark, or indeed a design, or indeed a copyright work. But yeah, when it comes to trademarks, it doesn't matter if it was developed by an AI or a person, or it was a footprint of a dog. It just doesn't matter. You can still register it as a trademark. And obviously a trademark applies to a business, and a business may have an idea and use that idea, and they can use the trademark to attract people to exploit their idea. If the question is broader, and it's can I protect an idea or content? We're back to the questions I've already addressed about Davis and inventions and copyright works. I hope that answers the question. On the international standpoint, I don't know the answer. I just know the situation in the UK is there's no test, but a trademark was created by a human. I would be surprised if there's a requirement that a human created a trademark elsewhere.
All right, thank you, Mr. Matt.
I think your mic is turned off, Dennis.
Okay, sorry. I was saying we're still taking questions from our mentees. Are there more questions? Okay, before we have more questions from them, I would like to throw my own questions, and I'll be directing it to both Professor Samuel and then Mr. Gabriel. My question for Mr. Gabriel first is, if AI has the ability, you said in training, AI doesn't just undergo one form of training and that's for that. It continuously learn with continuous usage. As people use it, it trains itself with the information that is being imputed into it. If that is the case, where the person who designed that system is not longer the one training it, but now the machine itself, it's learning from the user's standpoint. If there is a case of infringement of copyright, who is to be held liable? Is it the machine itself, or the person who generated or who did the algorithm for that AI?
Okay. Very quickly, again, like I said, I'm trying not to answer questions on copyright and IP because the professionals are here. So I would rather leave them to answer that. But again, let me explain the issue with continuous learning and the pre-training and reinforcement learning. Like you've mentioned, and like I said earlier, there is a basic level of training at the point where you build softwares. There's a basic level of training. There are things that it has to be trained with. Basically, the initial data that it comes with. There's also an algorithm. So no matter how much you train a system, there's an algorithm that determines certain things, the nature of the feedback or something, right? So there's a large chunk of liability still going back to the original, the person that originally trained the system. However, I'm not sure, of course, I think Prof would also answer that. I think Matt Harvey would also give feedback on this question. There are instances where there's a considerable level of training beyond what may have been foreseeable at the point of originally creating the system. That leads us back to the issue of the black box problem. And I said that it's simple philosophy. You either create what you can predict the output, or don't do it at all. It's a primary idea with safety. If you're not sure of what the outcome, they use this a lot with autonomous weapon systems. If you're not sure of what the system is capable of doing, then don't build it. So from that perspective, it's difficult to place responsibility on others. But I'm not sure what happens with intellectual property. I'll leave Prof and Matt to try, to give feedback on this also. Thank you.
Thank you very much, sir. Can we have Mr. Matt give feedback on that question?
Sorry, can I just double check? The question is whether the user of generative AI is liable for an infringing output or the platform? Or was that the question?
Yeah, the question is if the machine itself is liable for infringement, or the person who designed the program is liable for infringement. In case if there's an infringement based on if the machine itself, while learning, right, while training itself, learns, got details or got information that became a resource for infringement.
Okay.
Okay. I wanted to explain whether maybe it's, you would understand better if I give just a brief understanding of how I got the question, right? So the creators of the system have done the original work. They built the system with the original data and everything. And now, due to the fact that there's, the idea of reinforcement learning, more people are now contributing data to the system, and they're also getting data out of the system. In whether it's a breach somewhere, who is responsible? Is it those that contribute or get data from the system, the subsequent trainings on the system, or the original structure that that was done originally from the system? That's how I understood the question.
I mean, very complicated, and it's so complicated it's very hard to actually figure out what the scenario is as well, because there's so many things that might be going on. As just some very general points. First of all, the AI itself has no legal entity status. It can't be liable for anyone. The only people who are ever going to be liable are people and companies at this time. So the other general point I would make is it's pretty established law so far that if I generate equipment that's capable of creating copies, like the old cases where you had 2 cassette decks and you could take an original cassette and you could copy it. The way the case law has happened, certainly in America and in the UK, is as long as there are legitimate uses for that technology, the manufacturer isn't liable just because some people misuse it to make copies. In the UK, there's also a concept of equipment specifically to make a specific copy. So if you have negatives of a photograph or some other equipment that generates a specific copy of a work, you're liable. And I think that's really a gray area when it comes to AI, because the AI provider chose the copyright works on which it trained. And it arguably enabled this AI to generate certain kinds of copies, and maybe they would fall under that kind of liability. I think what's very interesting is that some AI providers, when they launched their products, gave examples of give me a work in the style of, and gave an artist, and they've removed those examples from their website now, because the other way in which a manufacturer or a supplier can be liable is if you encourage infringing activity. And that goes back to the cases about file-to-file sharing, Napster and the like. It wasn't that their technology was only used for bad things. The problem was they boasted on their websites about the copyright infringements you could receive by using the technology. So I think it all depends on the factual scenarios. But if the AI provider is giving you a generic piece of equipment, and you've either put in a prompt to extract something infringing, or you've trained it yourself on infringing materials, it's probably going to be the person downstream doing that activity who's liable, rather than the AI model supplier in the first place.
All right, thank you very much, sir. Professor Samuel, do you have something to add on that?
Yeah, I just want to guess, based on the Napster strategy, the law, that Matt has already done justice to the first arm of the question. I mean, it's going to be human being until the law catches up and says AI is an author, then we can hold AI. But, that's an easy one. But this other complicated one. So I'm remembering the Napster case I started, and the courts in the US, how they arrived at liability. I think it's also going to be a strategy, a litigation strategy, because you might not be able to, if you're a litigator, you might not be able to catch everybody down the commerce stream who infringes. That's utopia, So let's say anybody who infringes, let's assume that there's an infringement. Let's start from there. Assuming that there is copyright infringement. So you have to draw the line. The manufacturer, like Matt said, who manufactured the device that is causing me grief? Okay? So company X, who is the owner of the generative AI system, will be the first person responsible. Okay? So then the issue of strategy or damages, so who is using them? Who has replicated that same device for the purposes of infringement? Because these devices might have dual purposes, dual uses. So I know it's an abstract question which might come alive tomorrow, but I think it's going to be more of strategy, because the law, I think, is already there. The court, when it has to do with infringing of IP rights, copyright, patents, the line who you hold responsible, and the defendants, what kind of defendants, how much money do you have, deep pockets. You don't just want to sue any person down the street because he's infringing. You don't want to use 1 million to chase a litigation that you will not get anything. Except there's ideology there. You just want to stop, you make a statement. I don't know who chases ideology with millions of dollars. So that's how I look at it. Yeah.
All right, thank you very much, Professor Samuel. So are there still more questions? Are there any more questions? Okay, if there are none, okay, I'll just take my last question and then we'll call it a day. All right, so for my last question is, we talked about how that AI, there's a tendency for AI to take over jobs, to take over the populace jobs, right? In a case like that, where we consider AI, or we should consider AI also as a business in that sense, because AI is commodity, right? From the side of the producer, it's commodity. They are creating a product that is supposed to replace or solve certain issues within the world. So if we consider AI as a product, and with all the issues pertaining ethics, IP laws, and the rest, is it possible that AI will fail in the market in its drive to replace jobs? Human tendencies and the likes, will those things stop AI from making advancements in terms of technology? Because we have seen technology fail. In the 1950s, it was said that by now we'll have flying cars, but we don't, right? So there are those protocols and there are prediction that technology will do so and so, but it tends to fail. So is that tendency there with AI?
Well, I'll just quickly add. First of all, you said AI is AI as a service. AI is created to solve problems. Yes, Guns are also created to solve problems. These nuclear weapons are created to solve problems. It just depends on how you look at it. Now, if you're the one affected by on the other end of the gun, then you're the problem that has been solved. If you're the police officer handling a gun, then the gun solves your problem, right? So I think it's the same thing with AI solving problems. Technology has always been, the idea is it comes to solve problems. Everything, every kind of innovation is presumed to be aimed at solving problems. But then we have to create a balance. Cars are created to solve problems, but if children are allowed to drive cars, it's going to solve one problem of taking one person from one place to another, but it's going to create other problems of killing people because there are going to be accidents. So what I think is, first of all, there has to be some balance, right? I mentioned this earlier that legislations are not enough. They are never going to be enough. At the pace of AI, currently and in the near future, we're never going to have enough legislations to completely regulate AI. It's near impossible. If you look at the EU AI Act, so many people till today we are towards the end stages of the trilogue, and there are still so many places where even the actors are disagreeing. We're not going to have everyone agree that this is where we should all place the guardrails of AI. But then at least let's have some sanity. Now on the issue of job losses, personally, I think this is one of the things that we can see coming, but we can barely protect ourselves from. Because like you mentioned, AI is also a service. The person who is fielding AI in the markets is also looking for money, right? And sometimes, especially with the very big capitalist companies, they are just out to make money. Prof has mentioned you having to go to court with these guys. In many instances, it's not going to sell through. These are companies that have experts in many areas. They've studied IP, they've studied many things before they build some of these technologies. So it's going to be hard to trap them in places. What is best, and I usually would advise people, is just find a way around it. Many people will still, get affected. In one of our sessions, I mentioned that in the early 1920s, a car was, then not something you could hear of. Anyone that had a horse was a rich person. And barely 10, 15 years later, the society changed completely. Now, so many industries and the people that were in those industries had no jobs. The people that produced food for horses, that was at the end of it. The people that, all sorts of people that, the industry that dealt with the wood that built carriages, the people that built the roads for horses to run on, all sorts of industries, people had to get laid off from their jobs. It doesn't mean that every time these predictions fail. Many times they fail, but many times it's easy to predict that this is not going to fail because it's already happened at a very alarming rate. So what I think is we just have to create a balance. There's no need thinking that, well, it's likely going to fail or it's not going to fail. We need to begin now to create a balance. Either people find alternatives or we slow down, which of course, good luck to that, or we slow down on the innovations. This is something I don't believe is going to happen. But basically, we can't just say because we're trying to solve problems, we produce whatever we think can solve problems. So that's what I think.
Okay, thank you very much, Mr. Gabriel. Do we have any other comments from our mentors, Mr. Matt, Professor Samuel?
Just adding to Gabriel, you see, I following the disruptive technologies for a while now, and we always have these parables, horribles. Oh, there's gonna be doomsday. But experience to us and my research has shown me, just like when DMCA, TPMs came, technical protection measures. So technology is going to destroy creativity and invention. But where are we now? We have iTunes, we have WhatsApp, we have what we are doing now. It's part of the disruptiveness. Now we are talking, you are in London, I'm in Saudi Arabia, and nobody has died, So yeah, Gabriel is very right on that. I mean, we can smell it when it's going to succeed, and we can smell it. That's the truth. the money people out there will tell you, those who do this for a living, will tell you the amount of money invested in this industry right now is mind-blowing. And in not just the investment, the outcomes we are seeing so far. We've not even talked, we're only concerned right now about law. We've not talked about healthcare, how much AI is helping in the healthcare industry, saving lives. So I don't put it in the same way of the earth is going to collapse in 1970. Cars are going to fly in. No. This is something we can feel and see. So it's better for us to join the industry. Look, my last talk here, I said in Nigeria, I'm actually encouraging the people in the creative industry to invest in the industry, to become owners of generative AI systems, because most of all these companies, OpenAI, it's mostly from the northern hemisphere. In the developing South, we don't have people who are investing. I'm doing active research on this subject. I'm going to be presenting a paper in December somewhere in Ethiopia. We want to see the deep pockets in Africa, in Asia, develop technology, put in money. It's all, have companies own these systems so that we won't be crying tomorrow and say, oh, we are far behind. Yeah, we've been behind for a long time, but we can catch up. This is one area that can make us catch up because we have smart resources, smart people from the global South. We collaborate a lot. Matt is here now. We are learning a lot. I'm learning from all of you here. So this is how we pull these things together. So I think there's a bright line. Thank you.
All right, thank you very much, Prof. Okay, Mr. Matz, you also have a contribution.
Sure. So I agree with everything I've already heard. And returning to your question, which I understood to be, can people stop it? Assuming it's going to replace jobs. And interestingly, for what it's worth, Elon Musk said, I think this morning or yesterday, that in the future, AI will replace all jobs and people only have jobs if they want to. I don't know if it's right or wrong. I totally agree with Professor Samuel that previous disruptive technologies have just created different kinds of jobs. So you've had people displaced from one activity to another, but we've created new jobs. AI might be different. It may displace so many people at once that even if new jobs are created, there'll be real hardship, I'm sure. But what can people do to stop that? And I totally agree with Professor Samuel that the best thing for people to do is to engage and to shape it rather than try to stop it. I think there are limited ways in which you can stop the advance. I would say in Europe, for example, genetically modified food hasn't been deployed much because the public wouldn't accept it, rightly or wrongly. And that's partly about the advertising, policy, lobbying, and all sorts of factors. And I also agree with Professor Samuel that serious money is going into making AI work. And I think that the people are not going to win the lobbying argument or what happens. I think the other tool that people use other than voting with what they spend their time using is what they ask their governments to do and what they elect their governments to do on their behalf. But I think it would be a very brave government indeed who tried to stop AI within one country, because I think the productivity promises, right or wrong, appear so attractive that it would be a very risky strategy for a country to take. So in conclusion, I think I'm afraid there's very little I think people can do to stop AI, but they should try to influence it.
Thank you very much, Mr. Matz, for that contribution. Thank you so much for addressing all the questions, Mr. Gabriel, Professor Samuel, all the questions that we've had so far. We'll come to the end of today's program, but before we go, right, we would like to have our picture of time. So we encourage all our mentees, also all our mentors' profile pictures or videos rather are turned on. So we like to have our mentees also turn on their videos so that we can capture their picture. Please, we encourage every mentee to turn on their video camera so that we can do that. Okay, can we have more mentees turn on their video if that's possible? All right, thank you very much for that engagement. All right, with that, we've come to the end of today's program. We've come to the end of today's session. I'm sure everyone learns a lot, right? I personally learned a lot from everything that we've had to discuss on the intellectual property protection of AI and ChatGPT. We look forward to having our mentors in subsequent quarters and subsequent sections also come help us with other topics as regards AI and other matters. Thank you so much, sirs, for joining. Thank you, Mr. Matt. Thank you, Professor Samuel. Thank you, Mr. Gabriel. Thank you for all you do for us at JIIPC. Really appreciate all the effort you put and the time you invest into this program. So with that, we've come to the end of today's program. I wish everyone here a wonderful day ahead. Do all have a lovely day.